Joining me from Brisbane is my regular guest, Amanda Stoker, former Commonwealth Assistant Attorney General and now a Distinguished Fellow at the Menzies Research Centre. Look, Amanda, I'll confess I'm not a constitutional lawyer. In fact, I'm not a lawyer of any kind. So, look, can you help me get my head around this proposed change to the Constitution? Because I don't think I'm the only one who's confused. What do you think, what do you understand by this voice to Parliament? What exactly will it look like?
Well, Labor's proposed some really general words being put into the Constitution that would empower the establishment of an Indigenous voice to Parliament. But because of their generality, it is in essence a blank cheque in order to be able to set up something that could take really any form. We really don't have that detail from Labor just yet. And so we can start with the big picture problems and implications of this. First, in principle, I think it is wrong to divide Australians on the basis of a racial attribute in the founding document of this country that's designed to set up our institutions for all. I think that's a really dangerous precedent to set and not one that we want to see as a guiding principle for our future. But there's also practical problems that come with it too. Indigenous people are not a homogenous group of people. You know, even in our parliament, we've got Jacinta Price, Linda Burney, Lydia Thorpe and others, but you couldn't get three more different views on what's needed to advance the lives of Indigenous Australians than you would from those three example women. Indigenous people don't speak with one voice, and so the idea that there can be a voice for an entire population of people is really very unrealistic. And then there's, how do you choose it? How big is it? Is it elected? Is it appointed? What should be its effect? Advisory? Should it bind government? Albanese said it'd be a brave government that didn't follow its recommendations, but does that mean the voice will have an effective veto over executive government? These are really, really big questions, and that's before you even think about what should they be advising on.
Well, look, as I understand it, the government could have introduced something like this simply through legislation, simply through passing it through Parliament, but they've chosen to put it in the Constitution for whatever reason. What are the pitfalls of going that extra step, of locking it into our founding principles?
Well, the problem that comes from putting it in the Constitution is, from the perspective of someone who supports the idea, it makes it harder to achieve. From the perspective of someone who's really cautious about the harm this could do, once it's in, it's really inflexible. You can't change or adapt in the way that you might have if it was set up by legislation. And so the expert panel that was appointed by the coalition government to consider this issue suggested as one of the ways forward a legislative option, so that as we sort of iron out what works and what doesn't, or even as we come to understand the dangers of dividing people by race, it's something that's easily adjusted. You don't get that if it's in the Constitution. The very fact that Albanese has jumped straight to that constitutional mechanism, though, speaks to the fact that this government seems to be all about political gestures, all about feelings, but it's not about substance, and it's not about the practical ways that we can improve the lives of the most disadvantaged people in our communities. It also invites a whole lot of problems. We've already heard from the migrant community, well, where's our voice? The LGBTI community might well say, we want a voice too. Women generally might say, where's our voice? People with a disability. I mean, where does this stop? The far better principle on which to grow Australian society's strength is to focus on what unites us from the inside, the characteristics that make us all good human contributors, rather than the colour of our skin or the colour of our hair or any other randomly selected genetic attribute.
So look, Albanese's approach seems to be, okay, look, just give us a in principle yes or no and we'll fill in the details. My sense is that's just not going to work. I mean, the electorate is actually a whole lot smarter than that. Australians are not going to give him a blank cheque, surely.
Look, I hope that's right. But the thing that Australians should keep in mind is that as he asks for that general principle authority, he's actually giving a bucket load of scope to a future High Court to interpret whatever they think those words of generality mean. That could very well mean you've got a High Court that can strike down laws on the basis of insufficiently considering the views of a voice, for instance. You invite judicial activism when you put in very general words to the Constitution and say, well, we've got a principle, we'll let the details get worked out by the court later. That's enormously dangerous and it's unaccountable. You can't hold anyone accountable for what judges do. Far better that it be in the hands of politicians who every couple of years you can tell them precisely what you think.
Now, I've heard some fantastic maiden speeches in the Senate. One, Senator Amanda Stoker, I think, gave not a bad speech, as I recall, from that day. But look, Jacinda Price's maiden speech was just something amazingly special. And I think this could be a game changer in this debate. Yes, sure, look, she's a backbencher and a very, very new one. But because of who she is, where she comes from, and the constituency that she represents, I think she commands enormous authority in this. She's got effectively the skin in the game, to be quite literal about it. Do you think, you know the dynamics of federal parliament, the dynamics of the party room, will this intervention settle the debate, at least on the coalition side?
I think it will be enormously unifying on the coalition side. Jacinda's speech was an absolute cracker for being straight shooting, honest, but also raw about the challenges that the people in communities like hers face. And she really beautifully drew out the need for practical, pragmatic solutions that matter on the ground rather than fluffy gestures that make elites in the cities feel good, but not keeping little girls safer, not keeping women safer from domestic violence, not keeping men away from drugs and alcohol, not keeping food on the table, not keeping people in a job or having the dignity of starting a business. She's so real, so sensible, that I think she will have huge weight in the coalition party room. And I am really optimistic that her contribution to the debate more widely in our Australian community will help people to see that we've got to do more here than just virtue signal about how much we care about Indigenous people. What we really need to do is get on the ground and deliver what they need. It's not about symbolism, it's about the nuts and bolts of everyday life.
Yeah, absolutely. Look, in the few minutes we got left, Amanda, look, with everything else that's been happening in Canberra, I think some people may have missed the implications of a decision that Mark Dreyfus, the new Attorney General, made recently, and that was a decision not to appeal the landmark Love versus Tom's decision. First, could you remind us of that precedent, of the precedent that was set by the High Court in the Love versus Tom's case, and why the Morrison government, and you were closely involved in this, why the Morrison government decided it had to be appealed?
Yeah, I think this is a real, it's been deliberately done quietly by the Albanese government. They don't want Australians to see what they've done here. The Love and Tom's decision was one that came from the High Court, and it put forward a really quite disturbing authority, I would suggest, for ordinary Australians. And that's the idea that there always used to be two categories of people in this country, citizens and aliens, ones who have citizenship and ones who don't, but they've got permission to be in the country. The High Court said there could be a new category, non-citizen but also non-alien. And they linked it to the idea of indigeneity. That's really worrying because, in effect, it outsources a big part of the decision-making about who gets to be present in Australia without the ability of the government to regulate their presence to Indigenous communities. And so in the case of Montgomery, an appeal was launched to the High Court by the coalition government because Mr Montgomery was born in New Zealand. He moved to Australia at the age of 15. His mother was Australian, his father was of Maori background, and he was, despite having no Aboriginality in his background, accepted as part of an Indigenous community. And so this is the idea that somebody who's got no Aboriginal background, wasn't born in Australia, isn't an Australian citizen, can nevertheless, despite committing violent crimes, not be allowed to be subject to the migration laws of this country. Now, that doesn't pass the pub test. It's abhorrent, really, and it needed to be the subject of a rigorous appeal. But Labor have quietly shuffled it out, content with that to remain the law in this country.
Well, look, we're out of time. We'll have to come back and revisit this case. The idea that somebody who's not an Australian citizen can become culturally adopted by an Indigenous group here and therefore be above the immigration legislation is just something which is too troubling for words. Look, Amanda, thank you very much for joining us once again and look forward to talking to you next week.
Thanks, Nick.
Thank you.